welcome to this edition of You on the Law. On You on the Law, I add law to the news. I discuss the issues of law in the breaking news. I also create time to discuss other issues surrounding everyday living. My name is Ekemi Nudim. I'm a legal practitioner, and I'm always glad to know that you are there, keeping me company on this channel. In this edition of You on the Law, I am discussing the death of Sylvester Oromoni, the 12-year-old student of Bowen College in Lagos State, Nigeria. The news broke recently that the boy was bullied, and as a result of complications arising from the bullying, he gave up the ghost. The parents did everything to save his life, but he could not withstand it, and unfortunately, the boy died. Now, expectedly, there are issues of law arising from what has just happened in Lagos State, Nigeria. And this edition of You on the Law is dedicated to addressing these questions, the questions arising, these issues of law that have arisen. I will do that as much as time can permit me on this very episode of the show. The number one question here is, can children below the age of 18 be subjected to criminal trial and accordingly sentenced to death and then taken to prison custody? This is a critical question. Now, the question has arisen as a result of the fact that most children in secondary schools are not up to the age of 18. Most senior students are between the ages of 14, 15, 16, and at most 17. And most of them are not up to 18. So, if the senior students that caused the death of Sylvester are not up to 18, what will happen? What's the position of the law on that? Now, here is it. There is what is called the age of criminal responsibility in law. And children that are below the age of 18, in most instances, are said not to be criminally liable. And so, there are some offenses that such children will commit, and the law will not hold them accountable because it is taken that they do not have the mental capacity and the intention to commit the offenses that they committed. So that's the law, but that's the general position of the law. To every general position of the law, there are exceptions. And one of the exceptions comes in when the offense complained about is a capital offense. In this case, the offense of murder. And so, when a child below the age of 18 commits the offense of murder, that child will be held criminally liable. So from the age of 7, 8, 9, 10, 11, 12, and beyond, a child who commits an offense, the child who commits the offense of murder, and the child is within that age bracket, that child will rightly be held accountable in law and will be called upon to answer to his deeds. Now, the second question is this. Can these children be tried in the regular court? Here is the answer. They cannot be tried in the regular court because they are taken to be juveniles. They are not adults, so they cannot be tried in the regular court where adults are usually tried. So what will happen is that they are going to be tried in the juvenile courts. In every state of the federation, there are juvenile courts that have been created by the laws of the states. In Lagos State, there are juvenile courts that have been created by the laws of Lagos State. Now, a juvenile court simply means a court meant specifically for the examination of the degree of culpability of children. And so they are not open to the press. They are not open to members of the public. Most times you have the juvenile courts in the judges' chambers. Inner chambers, it is closed. It is only open to parents, open to the prosecutor, or open to very few people. And trial there is not allowed for members of the public to participate in. Okay, so these children are going to be tried, taken before the juvenile court for examination of the degree of culpability. Now, what's the procedure at the juvenile court? Can they be sentenced at the juvenile court if they are found to have committed this offense? Here is the answer. The law does not allow the judge of the juvenile court to use certain words. For instance, the judge of the juvenile court is not allowed to use that you are hereby convicted and sentenced to death by hanging. The judge is not allowed to do that. So what basically happens at the juvenile court is an examination, a session of questions and answers, some kind of investigation by the trial court, by the trial judge, to get to the root of what happened, to see if truly the child has committed an offense, if truly the child had committed the offense that has been alleged. And when that is done, and the judge finds out that there is a case against this child, the judge does not proceed to convict the child and sentence the child to death by hanging or death by firing squad. What the judge does is to make a recommendation to the governor, and the governor is expected to then take the next step, which is to keep the child in a special kind of confinement, not taken to the regular prison, but maybe in remand home. And the child will be kept there, and the law says the child is to be kept there at the pleasure of the governor. So the governor decides what happens to the child thereafter. The governor decides whether the child is to stay there for 1 year or 2 years or 3 years or 4 years, or whether not to even stay there at all. Because the law says at the pleasure of the governor. But the reality there is that the child is not freed. The child is not allowed to just walk away from what the child had done. The law still has made provision for a finding to be made, showing clearly that the child committed the offense, and also for the governor to, at his pleasure, handle what happens after the findings of the juvenile court. Now, the other question is, there are insinuations that these children have been taken abroad by their parents. How is the law going to handle that? And here is the answer. If it is true that these children have been taken abroad by the parents, and the reason for taking them abroad is for them to run away from punishment, to run away from justice, then the parents that have assisted in doing that can rightly be arrested and then tried for being an accessory after the fact of murder. If the school authorities had also assisted in any of them running away from justice, such person, whether principal or vice principal or proprietor or co-proprietors of the school or housemaster, anybody that had assisted those children in running away can rightly be arrested and then tried for the offense, for being an accessory after the fact of murder. Now there is another question, which is the Lagos State government justified in closing the school at this time? Now, there are many issues here. A lot of people have said that the owners of the school, they have the rights in the constitution to own and run their property without interference from anybody. That's correct. However, fundamental rights are not without limitations. And so when reasons of security have presented themselves, fundamental rights can be curtailed in a way. Remember that it is the primary responsibility of government to secure lives and property. At any point that lives of people becomes endangered, government could have the right to walk into the premises of the danger and then ensure that the premises is closed, is sealed for the time being, so as to avoid other people from dying and so as to avoid an upsurge of violence from members of the public on the school. So it's also in the interest of the school that the school has been closed for the time being. And the law allows the Lagos State government to intervene in such situation where lives and property have been endangered. Now, there is another question, and that question is, can the school be held accountable for what has happened to Sylvester? Here is the answer. Yes, the school can be held accountable, but you must prove that the school was negligent. You must prove that the school had done something that needed not to have been done. You must prove that the school had failed to do something to protect the life of Sylvester. In which case, you are basically going to prove negligence against the school. If negligence is proved against the school, then the school can be held accountable in damages, which is to be paid to the family of Sylvester. But if it cannot be proved that the school was negligent, and that the negligence of the school led to the death of Sylvester, then it is difficult to hold the school accountable. It is very extremely difficult to hold the school accountable if there is no clear proof of what has happened. Now, how can the death of Sylvester be proved in law? Here is it. The death of Sylvester can be proved by bringing witnesses to testify against the bullying, to testify of having seen when this bullying was going on. Okay, so that will go a long way to prove the death of Sylvester. The dying declaration of Sylvester, wherein Sylvester mentioned certain names before he died, is also one of the ways that the death of Sylvester can be proved, by arresting the people that were mentioned and then interrogating them and then getting evidence to be presented to the court. Now, the autopsy reports can also be a veritable source of evidence to add to the surrounding stories to prove the death of Sylvester. It is very unfortunate that this young man, young boy, went to school full of life and only returned home without life. We do hope that this does not happen again in any school in Nigeria or in any school in other parts of the world. My name is Ekemini. Thank you very much for watching. I encourage you to subscribe to this channel so that from time to time we can continue to discuss issues of law as much as time can permit us. Thank you very much and remain blessed.